The divorce mediation process can be very complicated. First, we must remember that most divorces are settled in the mediation process. In fact, over 90% of my clients do. Even the ones that start off with opposite ends of the spectrum and are fighting on every issue, 90% of the cases settle. First, it is a good opportunity to at least see what the other side is going to make an issue. So at bare minimum, it's good to hear out what the other side has to say. Also, it's good for us to get some feedback from another attorney, who is the mediator normally, as to what our arguments are, and to get that kind of interchange. That's a positive even if we don't settle. Now, it's an informal process that you are going to be required to physically attend. And what I mean by informal is that the mediator is not the judge, just normally a very experienced attorney who's been through the ropes before, and both attorneys respect, meaning me and the other side, and we look for their input and to find out where possible middle ground is to settle, because it's going to be far less expensive to settle everything in mediation than to pay for me to go to trial and to argue your issues in court. Also, in court, the judge does not have your personal life always on top of your mind and what your wants and desires are. They are just going to rule by the law and cut the baby in half, so to speak, where the mediator can create some, flexible and creative solutions, and a lot of horse trading can go on in mediation, which does not happen in court. Normally, both sides are required to pay for their portion of the mediation, 50-50, and both sides are usually left like they lost a little something and gained a little something, because that's where a true middle ground is. And it's normal that in a few weeks after the mediation, you're going to feel like you gave up a little bit too much, but that's normal because people remember what they lost or what they gave up, not always what they gained. I like to go into a mediation process with a chance to have discovered with you 3 separate approaches on how to get what you want. So plan A, B, and C, so that we have strategies before we go into mediation, and that way we're well prepared and we can execute our strategy in mediation. And finally, you're not required to agree at mediation. You can partially agree, and whatever you partially agree to can be written up and signed by the judge. And whatever you don't agree to will go to court and you'll have a trial. Remind me to tell you about the story about Pahokee. Thank you.
Hello, this is Eric Yankwit, and thank you for watching our videos. I hope you found them informative, but remember, they're based upon general information and on current Florida law. To find out how they apply to your specific circumstances, please visit our website at yankwitlawfirm.com. And please, for a free consultation, ask for Eric. Thank you.